All right, so it's 4:03. I think we're happy to start. Just to start as a disclaimer, obviously, no matter what I tell you guys and what we talk about on this particular presentation, nothing establishes an attorney-client relationship between us and you separately. When it comes to the legal advice that's rendered, it's meant to be general. It will never supplant or replace a attorney consultation. So if there's anything that you want to know more specifically regarding your case, your hopes, your dreams, and your journeys, just let us know, reach out to us, and we're more than happy to kind of set up that discussion. But yeah, the purpose of today's presentation is to talk about the O-1 visa. The reason why we've labeled this presentation Level Up with the O-1 visa, part of it is, of course, demystifying what the O-1 visa looks like when it comes to creatives, founders, and innovators. But a lot of the times when people are interested in the O-1, maybe you're on an OPT, or you're on a STEM OPT, or you're in a far more restrictive visa, kind of like the H-1B, where you're only allowed to work for one particular employer. So sometimes we do consider going into the O-1 as a little bit of a level up when it comes to the visa options that are kind of in front of you. So I've already introduced myself earlier in this call, but I'm here to reintroduce myself again. I am Nicole Ganar, the principal immigration attorney here at Manifest Law. I've worked in immigration for a while. I've held a lot of leadership positions at prestigious law firms. A lot of my work has to do with talent visas, business and immigration, generally speaking, along with E1s, E2s, and L1s. I used to, let's call it, be the account lead or account manager for really large multinational companies, but I've also worked with individuals all across the board for all different backgrounds to really support their immigration journeys to the United States. The O-1 is partially a personal favorite when it comes to dealing with cases. I find that they're very creative, right? I think it comes down to each practitioner and their willingness to advocate for a foreign national, and that's the reason why I love talking about it, because there's a lot of things that you can do to really put yourself in the right position towards an O-1 visa. But enough about me, let's talk about the O-1 generally speaking, right? So what is the O-1 visa and why should you consider it, right? Many of you are probably already aware of this, but the O-1 is a non-immigrant visa. It's a temporary visa for individuals who possess extraordinary ability or achievement in their field. It's valid for up to 3 years. And when I say it's for up to 3 years, it just depends on how much you can prove. If you have a company that's sponsoring you and they're saying that, hey, you know, we're willing to commit to 3 years, even if it's at will employment, then that's great. But sometimes some people will get O-1s only for 1 year if they only can prove 1 year's worth of work. The O-1 can be renewed in 1 year increments. That's what the law says when it comes to extensions. However, what I will tell you is that a clever attorney can make it into 3. Whether it's through arguing that there's a new employer or a change in circumstances, there are ways to kind of extend it beyond the 1 year increments. And why should you consider it? Why should anyone consider the O-1? Number one is that there's no maximum limit if the criteria continues to be met for the O-1. So unlike the H-1B that has a 6-year limit, the O-1 does not have that particular, let's say, maximum amount. The second thing is that there's no lottery requirement, which means that you don't need to enroll and win a lottery in order to qualify for the O-1, and you can apply for it anytime during the year, so long as you have a meritorious case to argue for it. Another aspect is that it opens up a path to other opportunities because you're able to work for multiple employers. And depending on how you establish the O-1, it also gives you the flexibility to add new gigs each time you get a new gig within your field of endeavor. And also potentially sets you up nicely for a green card. I think for some of you who are on this call who might be familiar, the O-1 is really considered the younger brother to something known as the EB-1A visa. The EB-1A is the green card version of the extraordinary ability pathway. It does have slightly different requirements, but generally speaking, in achieving an O-1, you're going to be on the right pathway or the right direction to potentially qualify for that bigger brother visa, which is the EB-1A. So the first thing that I do talk about when it comes to the O-1, outside of what is it, is there's a difference between 2 subtypes of the O-1. There is the O-1A and there is the O-1B. And to cut it pretty straightforward, the O-1A is for individuals who are in the sciences, education, business, or athletics. For the O-1B, it's mainly for individuals who are creatives. I will note to you that there is also a subcategory within the O-1B for individuals who are in the motion pictures and televisions industry, but that would be for a very specific, let's say, argument that needs to be made. But these are the fundamental differences, which is the requirements, or at least the categories that you can meet. For many of you who are on this particular call, I think the O-1A is the one that's going to resonate or fit you the most. A lot of the times we get a lot of interest from engineers and tech entrepreneurs, and the O-1A is going to be the better suited category. But just to read things off very, very briefly, you need to meet 3 out of the listed categories here, if not more. You can always argue for more. So for O-1A, it would be a receipt of nationally or internationally recognized awards. So if you won, whether it's a minor award within your industry, within your field, or if you've won something at a national level abroad, that would be something that would be very good to display. Separately, there's also membership in associations that require outstanding achievements to join. So if you are a member of a prestigious association that has really high standards, right? You need to go through a nominations process, you need to go through an interviewing process, and it acknowledges the fact that only those who are, let's say, the best or the top in the industry or with certain accolades can join. That would be a really solid argument for memberships. The third category is press about you in professional or major trade publications or major media. What I would tell a lot of people is that, press is an interesting one. It's also a premium category. I feel like it sets a lot of applications apart if you've been talked about in the general public. But this is also a very buildable and achievable category for a lot. And we'll talk a little bit about that later, because I would emphasize that the government doesn't say that you need to be only in major media like CNN and Bloomberg or the like. Trade media is equally as warranted. So if, let's say you're a financial engineering expert and you've been interviewed by a publication like Finextra or payments.com, that is equally as relevant to a CNN article. Next category that we're going to talk about as well is judging others in the field or an allied field. This is where you're going to be judging competitions or in part of a committee, not necessarily a hiring committee, but a committee for reviewing other people's work. Or alternatively, you're doing peer review in a journalistic context where you are reviewing research publications that are to be published in a journal or an academic journal of some format. Judging is a really good category to build into, and we can talk briefly about that as well, but it's also a very good category for individuals who are in the engineering and in the tech fields, because there's actually a lot of international resources that are looking for your expertise when it comes to judging competitions or judging some of these, let's say, publications that are coming out. Next category is original contributions of major significance. Just to briefly touch upon it, you did something that is original, something that is novel, or something that was evolved from a different methodology, and it was significant in your field. The question of significance can come from who used it, why it used it, how many people were impacted on it, or alternatively, it could be something that's a lot more tangible, right? Data-driven, which is like, hey, what's the amount of sales related to the work that you did? Or alternatively, if you have a patent and there's a lot of patent citations by really large organizations and we can see the utility of that patent, that is a really good way to show original contributions of major significance to the field. Last 3 categories to just touch upon it. Authorship of scholarly articles, right? Also a really solid category for people to build into, especially if you're in the research world. I will tell you guys a little bit of a hint, which is that it's not restricted just to academia. Sometimes people feel that scholarly articles can only be derived from journal publications, but the government does accept publications in spaces where it's targeted for other industry experts to review, right? So if, for example, you wrote an economics article, right, and you're an economics, graduate, or you're an economist, right, and it got published in a very, I wouldn't say it's prestigious, but like an established publication like The Economist, which primarily targets financial professionals, there is a way to argue this as authorship for scholarly publications in a non-academic context. That leads me to like the last 2 categories, which is lead critical role at a distinguished organization. You're working at an organization that is known within the field, or there is at least an argument to be said that it's distinctive from others that are like mom and pop shops. And you hold either a lead or critical role, right? Emphasis on or, it doesn't have to be a leadership position, so that so long as we can argue that your role is critical to the organization, there is definitely argument to be made for this category. Last one is high remuneration or high salary, where essentially you're being paid more than others, right? I find that each practitioner has their own benchmark. Some people feel like it's enough to be in the top 25%. Personally, just to, save yourself some, I guess, feelings when it comes to like potential ROVs. I like to see people in the top 10 to top 15%, right? But this calculation does depend on what we have in terms of the government statistics, and it's one that usually an attorney makes a judgment call for. Not to spend too long on the differences with the O-1B, but it is listed here on this slide. I want to let everyone know on this presentation that you will have access to this slide and also the recording for this particular O-1 webinar. So don't feel like if you're missing something or I'm not touching something specifically that you won't get that information, because we do have it here. But I do want to call out major differences between the O-1A and the O-1B. For creatives, to be honest with you, they do have it a little bit easier, right? Not only do they have lead critical role at distinguished organizations, they have a subversion or a secondary category known as lead starring participant in productions or events. Sometimes people feel a little bit too restricted by the production or events. They really feel like, oh, I needed to be in like part of a film project or like a very specific engagement. But I've been able to use this particular category to argue individual projects that you worked on at a company. So let's say you worked at a company like Meta and you were a creative strategist, right? You could argue lead critical role at distinguished organizations as a creative strategist on behalf of Meta, fine. But for every single individual project, let's say you did the Meta, Ray-Ban collaboration advertisements, or you worked with LVMH on behalf of Meta for a specific brand campaign, those individual campaigns could be counted as individual productions, even though they're part of your role at distinguished organizations. So that's the reason why with O-1B, I find that it's a little bit more flexible. The other thing I would also tell you is that unlike the O-1A category, O-1B, the significant recognition from achievements from organizations, critics, and other recognized experts, that's recommendation letters, really strong recommendation letters that explain why you're significant compared to the rest. That counts as recognition. And also one other thing is that on the second category here that's listed, where it's this recognition of achievement by critical reviews, published materials, I want to emphasize by or about you. So unlike the O-1A that doesn't really reward articles that talk about your own work that you wrote, the O-1B gives you a little bit of an open catch, right? Because if you wrote it, they accept that as the second part of the category, so long as we can make the argument that it's a recognition of your achievement, right? So I see some questions coming in. I will answer them if they kind of make sense in the context of the slide, but if not, I would wait towards the end when we have a Q&A session where I'm more than happy to answer some of these questions as well. For you, Ashish, when you're saying possible to expand a company using the O-1, we're going to talk about how that would be set up and how it looks like, right? In the following slides. So how do I qualify for the O-1? From the criteria listed in the previous slide, like I mentioned, you need to meet at least 3 of them in order to qualify for the O-1. And then further, and most importantly, and this is probably something that is much more effectuated in the last 6 months compared to under the Biden administration, the government applies a totality determination. So for a lot of you who might be familiar with the EB-1A that has something known as the final merits, it's kind of like a pseudo final merits. In this case, the government applies a totality determination where, for the O-1A, you must have sustained national or international acclaim and is one of the small percentage of those that have arisen to the top of the field. For O-1B is that you must sustain national or international acclaim and has achieved distinction in the field of arts, right? And for the O-1B for motion pictures, it's a really long sentence, but essentially it's slightly harder than the O-1B when it comes to sustained national or international acclaim. You must prove that you have an extraordinary level of achievement at a very high level of accomplishment. So you really need to be a cut above the else if you're like an actor or an actress and the like. Essentially, the government doesn't want to make it too easy for people who may have just started one thing that became quite popular in order to move on. So the main question that I usually get for the O-1 is, do I need an employer? There's a lot of like publications out there that talk about self-petitioning or like self-sponsoring an O-1. The answer to that question is like it's sort of or kind of. And the reason why I say sort of or kind of is that if you Google self-petition for the O-1, you'll get a lot of other firms that say like, oh, you can do it. But if you actually look at the USCIS website, the FAQs themselves actually say you can't necessarily self-petition, but there is a way to do it, right? So let me explain to start the 2 types of applications that you can file for an O-1A and an O-1B. Number one is the straightforward one where you have a direct employer. A specific employer opts to sponsor you for an O-1 application. Similar to the H-1B, when it's approved, you will only be able to work for that employer, right? However, the O-1 is transferable. You can transfer, change employers and the like. You can even file concurrent O-1s depending on how you want to structure it. But essentially, that's the direct employer model. You're here to work for a specific employer. The second kind of application is the agent petition, where there's a US-based agent, which is any US company, citizen, etc., who can sponsor you if you can prove that you will be working for multiple employers or on freelance and short-term projects. Essentially, it could be a shell company that is kind of signing off as being an agent. They're basically taking in the service of process, like taking in all the information, signing on your behalf, and also whenever the government needs to reach out to you, they will reach out to them and forward it to you. But in order for the agent petition to work, you must show an itinerary. You must show what you're going to be doing in the United States and that you have engagements in the United States, work for you to be doing. So just having an agent is not enough to make it to the US. And I also want to make it clear that an agent is not the Hollywood style of agent. So if there's a company that provides O-1 agent services, and I'll tell you that we also work with vendors who provide these services, they don't solicit work for you. Their role is 100% just being paid to sign the documents, right? And that's basically it. It is incumbent on you to have the work and the work to prove to the government of why you need to be here. For how does an agent petition work? Like I mentioned, US company, US citizen, or one of your employers can act as an agent. There are also vendors in the US that provide agency services. Number two is that you must have an itinerary. You must prove that you have work engagements and plans in the US. And just a few examples of how to prove that this exists. Contracts for work, correspondence between contractual parties, like emails that basically equate to an oral agreement, right? Alternatively, you can also provide a written summation, aka a deal memorandum, memorializing simple terms of an agreement or an oral agreement for services here in the United States. If you were to work with Manifest, we do have a template for you to take a look at, or a sample to take a look at, of what a deal memorandum looks like. Generally speaking, for a really solid O-1, I prefer having at least 2 deal memorandums to show that you have 2 kind of options for work in the United States for an agent petition, because that's the whole point of an agent petition, which is that you want multiple employers to be able to work with you. So what's the benefit of an agent petition? Number one is that it allows you to work for multiple employers, and one of your employers can be the company that you hold ownership interest in. So this is where everybody gets interested. How do I get into the self-petition space? Well, I usually tell people that the best way to do it is to do an O-1 agent and have one of the 2 deal memorandums be from your own company or a company that you have an ownership interest in. Why? Because you're doing a role on behalf of that company that you have an ownership interest in. And it's also a good way to funnel in new business. You can always be a vendor. You can always be an independent contractor through that entity that you have formed. And that's how I do it, because it's not really a true self-petition. It's just one of many opportunities that you're going to be working on here in the United States, one of which is your own company. It shouldn't be the sole one. I usually tell people to have at least one other thing going for them in order to really push for a strong application in terms of the O-1 submission, right? Second note is, if structured appropriately and you have a new opportunity while you're on the O-1 to do something, you do not need to declare it to USCIS to do it. So let's say you have an O-1B approved and you are a painter, right? You submitted 2 deal memorandums for 2 different art galleries that say that they're going to commission work from you and they're going to display it in their gallery over the next 3 years. If you're working in the United States and you had another gallery approach you, right? Let's just call it the Gagosian Gallery, right? The Gagosian Gallery goes to you and say, hey, I want to hire you now that you're in the United States on the O-1. I want you to do more paintings, right? You don't have to go back to USCIS and file an amendment for that, right? So long as it's within your field of expertise and your field of endeavor and the application was submitted correctly and structured appropriately, it's a new gig. You can just do it on an O-1 agent application, right? For a lot of people, that gives a lot of interest, or it's something that is the most important or vital, and why the O-1 is so attractive is because you don't need continuous filings or amendments, but so long as you structure it appropriately, and that's the most important part. When it comes to self-sponsorship, I told you, right? Let's be clear, USCIS does not allow for self-petition. I put a link here. If anyone gets access to this webinar, the link actually goes to the FAQ page where they say that you don't do it. But like I mentioned, an offer or a deal memorandum can be made from your own organization that you have an ownership interest in. It should just be one of at least 2 offers of work for you in the United States as part of an agent petition, right? And considering the nuances of structuring this type of O-1 and to ensure compliance, an attorney definitely needs to be involved. Daniel Flores, I see you have a question. Is it possible to have access to this information after a conference? Yes. So after this call, there is a way to kind of get a recording of this particular conversation. But separately, if you have any personal questions, please don't hesitate to reach out when it comes to your own personal matters and case. How do I start building a profile? So for a lot of you who are there, you may not qualify for the O-1 yet. So I know that I listed like a ton of criteria, right? Maybe you've met 1, maybe you've met 2, maybe you're somebody who's a student or someone who's approaching graduation and you're kind of sitting there going, what do I do? How do I get into a scenario where the O-1 is very feasible for me? Or alternatively, you're on an H-1B, but you feel stuck because you still can't qualify for an O-1, right? So how do you start building in the right direction, right? I always tell people to focus on the most buildable categories. So a lot of my conversation today is going to focus on O-1A. For creatives, it's a little bit of a separate conversation, but let's start first with this one because I think it's going to be helpful, right? So for O-1As or for engineers, tech entrepreneurs, and the like, I would say focus on press is one of them. Strategic PR investments can help, but I want to caution everybody here, right? There's been a lot of Reddit discussions and a lot of threads out there for companies or scenarios where people have gotten notices of intent to revoke due to investments in press, right? So what I want to have to caveat for this category is that you should only be hiring legitimate PR agencies that only pitch for organic media. So what does that mean? If a company says for $1,000, they're guaranteeing you 3 publications in LA Weekly, in Times of India, or in Outlook India, or Henoff, or Tech Times, that is not a good investment, and it's what the government doesn't like. Because how can they guarantee the publication? How is that possible? There's got to be a quid pro quo and the like, right? Because of that, I would recommend that if you are to invest in press, legitimate PR agencies don't guarantee where you're going to be published. They basically tell you the contract ends when there's 3 publications out there about you. There's usually a very intensive and manual pitching process that should take about 2 to 3 months, if not 4 months, to conclude at minimum, right? And that PR firm should not take everybody, right? Some people just don't have the credibility or they're not at the level yet to kind of be considered an expert or someone that could be quoted, right? So if you are going to invest in press, you should only work for an agency that focuses on organic media and does not guarantee where you're going to be published. That's a really good indicator, right? But other notes as well is that the story must be compelling. If you're coming fresh out of the gate and you don't have any story, anything to say or anything to talk about, then PR doesn't really make sense, right? And I also will note to you that niche media is okay. Going back into it, it's not about millions of subscribers. It's not about having millions of views on that page and the like. What the government really appreciates is if it makes sense, right? I want to talk about my previous example. If you're a financial engineering expert and you get profiled by a company like payments.com or Finextra, that's pretty valuable, right? It's less believable that Rolling Stone UK is going to be covering some financial engineers' work, right? So focus on not paying to play. It's all about kind of just investing in the right resources so that people can pitch you in the right databases, but they should not be guaranteeing where you're going to be published and when you're going to be published, weirdly enough, because that's normal editorial processes and guidelines take time to go through, right? Second way to kind of build towards it is judging, right? I always split it between traditional versus modern pathways to building towards judging. For the traditional pathway, I always tell people to focus on peer review. For those of you who are students and for those of you who are recent graduates, please ask your professors. You'd be surprised at the wealth of knowledge and the lack of kind of utilization of the local resources that you have in front of you when you're a student, right? Your professors actually know a lot about publishing. Like if you're going to be in academia and you're going to be teaching, by virtue of that, a lot of the times they're already doing peer review as part of their scholarly work or as part of their careers, right? Or at minimum, they know people who are already doing those things and they can get you into the right databases. For a lot of you who are related to computers or you do a lot of software work, I would strongly consider joining an organization like IEEE. And the reason why I want you to join IEEE has nothing to do with the memberships category, because I know I'm going to get blasted for people who are saying like, oh, IEEE is useless. But where they are still useful is those conference and paper reviews and the journal reviews that they ask a lot of their members to do. You get into their, I think it's called a CMA platform, right? You will have access to upcoming conferences that do need paper reviews, or you will have access to upcoming journal publications that they need for review. And that's how I usually use IEEE, not for the memberships argument, but literally for everything else, specifically for judging, right? When it comes to judging competitions, I always note to people, international competitions are okay, right? You don't have to be limited by Western-based organizations. You don't have to judge the biggest competitions in the United States, because I know how challenging that can be and how competitive that can be. But remember that you can leverage your skill set that you gained here in the United States, or if you're abroad, look at like what's happening locally, right? Your profile could be much more leverageable in a country like Singapore or in Hong Kong or in Dubai, right? Biggest rule is that you need to be judging professionals and not students, right? So if you're judging like, I don't know, the University of Buffalo's hackathon, right? The government's not really going to like that as much, because you're not judging professionals. Professionals are people who are in your field, who are actively working your field. So focus on competitions that are open to the general public, but don't hold yourself back. International competitions are okay. They can even be virtual. The only thing that I would shy away from are competitions that require you to pay to become a judge, right? An application fee is okay. Like if it's like $50, $100 to apply to be a judge, perhaps like they need to raise money for that part. But if it's like literally like pay to become a judge, I am not the biggest fan of those opportunities. But judging is usually a pretty quick way to build up towards an O-1, primarily because there's a lot of peer review opportunities out there. If you guys want something that's a little bit more specific to you, don't hesitate to reach out to us to schedule a consultation so we can discuss some of the things that we've seen for similar profiles, and we can go from there. Lastly is scholarly articles, right? Your school is a resource. I mentioned this for judging, right? Talk to your professors, right? I've had so many clients who didn't realize how much their former professors know a lot of people who need that research help. Being a co-author is still being an author, right? Being second, third, fourth, or fifth, that means you still have the credit under your name. Of course, the closer that you are to the front, the better it is, maybe for like an EB1A. But remember that what you're trying to do is build up that credibility and that research scholarship that the government is looking for to prove scholarly articles. So your professors and like the people or the deans of your college can actually be a really great resource for this, or anyone in academia. So if you know people who are graduate research assistants, talk to them as well. But the one that I really want to talk about the most is trade publications, which is the non-academic route. What a lot of people don't realize is that there's a split in kind of how the government interprets this particular category. They split it between academic publications and non-academic publications. Software engineers out there, it is actually more normal for you to not doing academic publications, right, than it is for you to be doing academic publications. And that's because software engineering and these kinds of fields are a much more practical field rather than being a research-oriented field, right? So what does that mean? You guys should be considering publishing technical papers and white papers in industry publications like D-Zone, Hacker Noon, talking about your work. But you still have to be able to prove two things, right? One is that it is a scholarly publication of some format. You're doing some research, sharing some knowledge, imparting some knowledge to the general public, and proving that knowledge, right? The second thing that you need to think about is, where is that trade publication and who's it directed to? The rule of thumb is that you need to prove that other industry experts are reviewing the publication. So weirdly enough, you got published by the New York Times, you write your own article and you share it in the New York Times. The government can come back and say that that's not for your target demographic. That's not for other industry experts. That's just for the general public to review. But if you're getting it published in somewhere that is much more specific to your field, let's say you're an HR person and it gets published in HR magazine or an HR journal, that is a very different conversation that can be utilized to argue the non-academic route for scholarly articles. Sorry, flipping on a little bit. So what is the timeline, right? So a lot of the questions that I get is, how long is all of this going to take, right? So it really depends. And the reason why it depends is it depends on how far along you are in, let's say, the credibility scale, or how much of your profile that you already have, right? If you come to me and you're like, hey, I'm already like 5 or 6 years into my H-1B, right? I've already been working for a couple prestigious organizations, or I'm working for Meta or Google and the like. I also have high remuneration, and I need my third category. Usually those individuals already have built-in credibility, and it takes much less time to really develop the remaining evidences that are needed in order to get into a position to file for an O-1. Right. The other thing that I will also say is that your effort and your focus in attaining some of these achievements can definitely shift that time frame. But we also have to balance it out with the sustained acclaim standard, where we need to show that over a period of time you sustain that acclaim. So if you're a really young student and you are someone who hasn't really done much outside of being a student, this could be the most challenging part, which takes the most amount of time for you to develop your profile, because we have to show that over a period of time you've sustained that particular acclaim. But once you've kind of gotten into a position where at least 3 categories are really sound and you have a solid application, then when it comes to the case production, it can take anywhere from 2 to 3 months to complete. Of course, there's going to be outliers. There are ways for us to expedite processes depending on like the certain scenarios, if you're running out of time and the like. But generally speaking, 2 to 3 months to complete, but some of this can overlap. If you're kind of just missing the final parts of like your portfolio or the evidence that is needed to qualify, but you already have a roadmap, hey, Nicole, by August, I'm going to have all of these peer reviews done, then there's nothing preventing me from preparing the remaining parts of the application from June until August, so that by the time we have these last vestiges, we can file immediately thereafter. Right? And then when it comes to case processing, depends on whether or not you pay for premium processing or regular processing. Premium processing means that you're going to get an answer within 15 business days after filing. For regular processing, you're looking at anywhere from 3 to 6 months, but it's a seasonal thing. It really depends on how busy USCIS is and when they get to your case. One of the luck of the draws is that when you file, it goes to a lockbox, it gets sent to a service center, and then you can look up how long the regular processing times are from that point. Common O-1 inquiries, right? When it comes to case processing. Number 1 is, can I stay in the US while my O-1 is processing? Yes, if the case is filed timely and accurately as a change of status. So if you're running out of time, let's say you're on the end of your OPT and it expires, let's say June 30th of 2025. If I filed the O-1 as a change of status prior to June 30th of 2025, then you're good to stay here while that application is pending with USCIS. That doesn't necessarily mean you can continue working. That would be a separate conversation, but you can stay here while it's pending. If it's not filed as a change of status, you can still apply for an O-1 for consular approval, but it means that you need to leave the country pursuant to your existing status. Go for visa stamping to activate the O-1 once it's approved. For question number 2, is it possible to go from F1 OPT or CPT directly to O-1? I would say yes. I've definitely done it before. There've been so many scenarios where this happened, even people from J1. However, you will need to have a very compelling narrative to convince the officer that you are now in the top of your field, despite recently having been a student, right? If you develop appropriately and you show that within a 1-year timeline or time frame that you're somebody who's very extraordinary and you manage to make it to the top in 1 year, it's possible. Right. But I will say that it's generally easier for people who have at least a little bit more into their careers or a little bit more time invested into their careers. Pitfalls to avoid for everyone. So even if you don't end up working with Manifest, I want you to remember some of these tips, whether it's working on your own O-1 or working with others on the O-1, right? RFEs and denials can happen, right? You can file a really good O-1 case and sometimes an RFE comes about or a denial comes about. But these are some common pitfalls to avoid that can help with your chances. So number 1 is generic or weak letters of recommendation, right? A letter of recommendation should not be a short paragraph. It should not even be a page. It really should be at least, like I would say in my point of view, 2 pages, because they need to clearly indicate the authority of the recommender and provide specifics as to why you are outstanding, right? So if they're saying lead critical role, it shouldn't just be, you're an amazing software engineer. They need to give concrete examples of some of the achievements that you've had within the organization and why that makes you someone who's critical to the organization. Another thing is that if you submit an unclear work itinerary, right? Work engagements, deal memorandums, and the like should specify the terms and conditions of your engagement. So you need to have dates in there, wages, rates, and the types of services that you're going to be providing to each of those individuals, even if it's a summarization of an oral agreement. Lastly is the lack of supporting evidence. Essentially, if you can't support your arguments, you tell the government like, hey, you know, I earned $120,000 last year, right? That was my salary. If you have nothing to prove it, you don't have a W-2 statement, salary stubs, or an executed job offer letter, or a letter from the organization that affirms your income, that's not going to be sold very well because it's just hearsay. It's just your words against the government's interpretation. So now we're here at Q&A time, right? So before I kind of answer all of the questions that are coming in through the comments, I do appreciate everyone's time for being here. This is a public seminar. So as a reminder for people who are putting in the comments, these are public comments. So if there's anything personal, I would rather that you reach out to us through our email here, the inbox, which is help@manifestlaw.com. For those of you who are streaming through Instagram and some of our other platforms, please take a look at our bio. There should be a link there for you to reach out to us as well. If you mention this webinar, you should be able to get a discounted consultation rate to speak with us. We're more than happy to see how we can best help you and support you when it comes to approaching the O-1 or anything else. All right. So now it's time for kind of me looking at the questions. Please kind of just start filling in. I'm going to go from top to bottom and I'll do my best to answer every single one. And if I can't answer something because it's too specific, I will let you know. So number one is from Ashish. Is it possible to expand the company in the US on an O-1, non-technical QA regulatory consulting? You can open a business on the O-1, but again, it has to do with structuring. If you took a look at my presentation and what I mentioned is that you can establish an entity in the United States and that could be one of the multiple job offers in an agent petition. And that would give you the most flexibility to expand that company through the O-1 basis. And also the field doesn't really matter, whether it's QA and regulatory consulting. Kiran, I have here, for someone who is on STEM OPT currently and having 2 jobs, can both employers apply for an O-1 with a future start date? For example, both employers are willing to file O-1 premium processing with a future start date to be 15 January 2026. Candidate has EB-1A approved, but priority date is not current and STEM OPT is expiring by January 16, 2026. Yes, the only thing that I will mention is that remember that the O-1 is not a true dual intent. I've seen very rarely, but we've gotten a lot of them approved. There are instances where the government can ask, like, what is your intention behind like the O-1, especially when you have an approved EB-1. But if you have a priority date that's still kind of languishing, that's okay. What I will tell you is that in this circumstance, you're going to have one person file the O-1 first, one employer file the O-1 first, and then you want a second O-1 approved as a concurrent employer. Trust me, you're going to want a good attorney who knows how to file those concurrent applications, because you'd be surprised on how many practitioners that I do know that don't realize that you can do concurrent employment on an O-1. Next one, Sai Prasad Sankara, and I see here, thanks for the session. First question is, would published patents fall under original contributions of major significance? And 2, if an individual has a published research article, but from 2016, would it still help with the O-1A for authorship of scholarly articles? For number 1, published patents can help, but it depends, right? You need to be able to prove that the patent was utilized and its impact to the field, right? At least you're able to prove that the contribution was original. That's by virtue of the patent. But let's say it was a US-based patent, right? What I traditionally try to look at is patent citations. Are there other large organizations or companies that cited to your patent, or the patent examiner cited to your patent as like the original work, right? That means that another organization or another person derived from your original work, right? So it's one thing to prove that the patent is a patent, which means that it's original. But when it comes to major significance, it's about the impact of that patent or how that patent was utilized. For the second question is, if an individual has a published research article, but from 2016, I would tell you that it's both a good and bad thing. It's a good thing because that means that you've done research in the past. So that sustained a claim question becomes an easier counter sell, right? Which means like, hey, he's had a claim since 2016. He started publishing in 2016. However, if that's the only one that you have, theoretically speaking, the scholarship prong is met, but I'm worried about whether or not you sustain the claim over a period of time. You need to be doing more scholarly articles, or you need to be kind of putting yourself more out there in order to really prove it. But it technically does count. I have Kiran, can someone have 2 O-1 petitions, one sponsored by an employer? Oh, I already answered that. Essentially, yes, but not usually. I haven't had this happen where it's an employer and an agent-based one. I think I've had it happen once with a big company that didn't want to be involved with the agent petition. My understanding is that you can still do concurrent filing for it, but I would be careful. I would rather kind of try to convince the employer to do an agent-based one or join the agent-based one. Plus, they don't have to pay for the cost. It's really only one cost then. That would be my argument to them. Beside Prasad, with an agent petition, does the contractual party need to know, or would they be disclosed that the individual has work engagements? To be an agent, yes, because you're signing like an agent petition, like you're basically claiming to the government that you do have multiple work engagements, right? But signing a deal memorandum or the offer to submit it to USCIS doesn't include the whole entirety of the filing. They will have to acknowledge that there's an agent representing the company for the purposes of USCIS, but technically speaking, there's not really a disclosure. For next question after that, Ashish, published papers in reputed journals like Springer and PubMed would count for founders where the papers were passed of master's study. So I don't know if there's a question in there, but what I will say is that if it's a reputable journal and you published in there and you're an author, there is a good argument to be said for scholarly articles. And maybe other things too, but we would need to take a look at what those publications are. But I don't see what's wrong with some of these publications so long as they're not predatory journals. Next question is, at what point letters of recommendations are required? Are they mandatory? Well, the letters of recommendation should be produced while the application is being put together, right? You need to have it for the filing, right? But any good attorney would be very much involved with the drafting of those applications and the editing of those applications, not applications, but the editing of those letters of recommendation. Because a letter of recommendation serves as the backbone of a lot of these O-1 applications that are out there. What a lot of people don't tell you is that a lot of the adjudicators, they don't necessarily have time to see like every single page of like a 500 to 600 page filing, right? They might take a look at the O-1 cover letter. That's why we try not to make them like superbly long. Like they really shouldn't be like 50 or 60 pages. They really should be like a really solid summary that touches like the really good points of your application. But they also read the letters of recommendation a lot because they do alliterate and do explain very carefully what makes you so outstanding. So they're really needed for a really good application because it's very hard to prove like lead critical role, for example, without someone kind of commenting on what it is that you did for an organization. Right. Can I transfer? So this is Sivad Nami. Can I transfer to a company with 100% equity as owner? So I actually don't know what you mean as a question, right? I think this is something that maybe you want to like shoot us an email for or like schedule a consultation. But if you're saying like, hey, can I do an O-1 with a company that I'm 100% an owner of? We have to just be careful that it's not a self-petition. Like that's like the biggest thing. You can have one of the multiple offers for a deal for the agent petition be from a company that you have an ownership interest in, but I will say that this is a conversation to be had in terms of structuring. B and S, they are saying, are dentists eligible for the O-1A category? It depends. They can be, right? It kind of depends on what it is that you do as a dentist, right? I will say that sometimes doctors and dentists have it the hardest because they're not really interspersed in like the research elements of the field. But I would let you know that there is arguments for comparable evidence. I find that dentists and medical doctors and physicians do a lot of conferences. They do a lot of conference presentations. So even if there isn't a category for conferences, there should be a reasonable argument to say that these conferences for these physicians and the like are much more prestigious than them publishing like scholarly articles that are out there. But there are ways to kind of get you into that right spot, and I do know dentists who are on the O-1. For Juhi, do I need a job offer letter or a research position to apply for an O-1 as I am on an F2? I think earlier on the webinar, we kind of mentioned it. You either need a direct employer to sponsor you. That means that they're willing to sponsor you for the O-1 application. Unlike the H-1B, though, you can pay for the whole thing. But they need to be willing to sign that paperwork, or alternatively, they need to be willing to give you something known as a deal memorandum or affirmations that you have work waiting for you in the United States for an agent application. For Renfeng Ke, how many press articles do you recommend to get? It depends. It's a sliding scale, right? I think some people say 3 to 5, some people say 6 to 10, right? I think obviously for every CNN article, it's like worth its weight in gold compared to like 3 or 4 niche articles. So it really depends on the quality of the publication, right? But also balance that with the organicness. But I would say that more the merrier, right? 3 to 5 is a comfortable range, but I don't like going to the bottom end unless they're really, really good articles about you. For VJ, do technical articles written in Medium count as scholarly articles? Depends on where on Medium, but I don't like it because it's a lot of self-publishing on Medium, right? I think that you should be publishing technical articles in technical spaces, in technical publications, and trade publications. SK, if the O1 got denied, when can we apply again? The government wants you to apply again the next day. You could actually have 2 O1 applications going at the same time if you wanted to, right? But what I will tell you from experience is that you want a cooling off period, because if you reapply again, usually what the government is looking for is how different can your application be compared to the last time that you applied. Now, sometimes if you apply by yourself and then realize that you need the help of an attorney for whatever reason, that can give rise to the argument of a sooner application, because maybe you just missed something or you didn't see something. But the reality is that I generally recommend a cooling off period anywhere from like 3 to 6 months, because you need to be believable that things have changed from you since the last time that you filed, if not more. Should I only be the first author for scholarly articles? I mean, it's better for you, but it's not the end all be all. You can probably be the second one as well. For Ashish, is a job offer absolutely necessary for one of those 2 petition conditions to apply for the O1? Is it possible to apply just based on expanding company in US? Again, if it's just your own company, you need to have one of at least 2 offers. That's it. Like, I think it's just a better scenario. I will always wholeheartedly say that self-petitioning is not generally allowed on the O1. It's literally on the FAQ on the website, right? It's one thing to have it as a deal memorandum, but it's another thing to kind of just have it as the solo application. But, you know, Ashish, when you're saying expanding company, I'm curious to kind of hear about what is that context and what you mean by expanding, like expanding from where. There could be other visas that kind of make more sense to you than the O1. Shrikant, how many citations do we need in total for research papers? So this is an interesting one. I don't see anywhere in the regulations that says that you need citations. That's just it. There's nothing in the regulations that say that you need citations. A lot of the citation questions that come up have to do with EB1A and like the final merits determination. Citations can help in terms of kind of establishing, let's say, original contributions of major significance. If it's a research paper that is significant to your field, how do you show it? Citations and usage, right? So if it's published articles that are just white papers or published articles in Unipublic, it's not necessarily based on reviews. Like for scholarly articles, again, it's about proving that it was catered to industry professionals and that the publication does target mainly industry professionals and industry professionals read it. Sivagami, can I transfer H-1B to my company with 100% equity as owner? Technically, yes, under the H-1B modernization rules, but I will tell you from experience that your company needs to have legs on it. You can't just open a shell company, right, and just have a bank account and call it a day. The government needs you to be able to show that there is a company there, that you are going to be an employee, and that there is specialty occupation work waiting for you. And also remember, you need to pay yourself a salary. The H-1B still requires you to pay yourself. How many letters of recommendation do we need for O1A? General bright line rule is anywhere from 5 to 6, but sometimes people have gotten away with 3 or 4. It just kind of depends on the quality and what you're arguing for. Anika Nair, for O1B, do I need articles published in newspapers and magazines? You're not required to. There's other categories to meet for the O1B, but press does help, right? Like newspapers do help if you're able to kind of get yourself out there to get into interviews. And of course, that's always going to be helpful for your application. Then we have an MJ. After getting an O1 in my field, medicine, can I work in a different field if I have a qualification in it? Not unless that second field is something that you are extraordinary in, right? So remember, for the O1, you are only really allowed to work or be approved for the category that you're extraordinary in. So if, let's say, you're telling me that you are a news editor and a graphic designer, I have to prove that you are both an extraordinary news editor and an extraordinary graphic designer. He says, can the letter of recommendations be from a senior doctor whom I worked under in a different country? I mean, there's a lot of like permutations of what a good recommendation letter looks like, but the government, in my point of view, doesn't really care if it's international or not. I like to have a diverse mixture. I want to have some people maybe who are in the United States and some people who are from, like, let's say, the home country or abroad. Kiran, I work for Amazon, who doesn't want to sign agent-based O-1 and doing employer sponsor for me at the same time. My second employer is willing to do whatever works for me. So after Amazon filed O-1 and that case is also with concurrent. Do I need to submit the whole petition again on concurrent? It's just a simple form of letting this, as a second employer. Okay, Karan, so this is actually very specific, and I really can't answer it in the context of this public webinar. I do think that this is more for a consultation because I need to know more about exactly what Amazon is doing for you. But what I will say is that, generally you don't want to step on people's toes, right? If you want to do a concurrent O-1, you technically can do a concurrent O-1, but you need to submit a whole petition. That is the case, right? It's not as simple as filing like a quick I-129 form. You need to, like, every single time you file for an O-1, you have to argue that you're a person of outstanding ability, even if you've already acquired it. I worked through Trump 1.0, and here we are again in Trump 2.0. Under Trump 1.0, they removed the deference standard, and I can see them removing them again. All right, so I think that's kind of all the questions that I see here at the moment, right? The reality is that I do have to jump off very soon, but if anybody has any specific questions, please feel free to reach out to us via the help@manifestlaw.com email. That's a really good way to kind of get in touch with us and schedule a conversation that goes into more detail related to your case and how we can best support you. I hope that today's conversation was very helpful, and I know that that was a lot of information to parse out, but that's what we're here for. At the same time, I know that we noted that we provided discounted consultation rates, but we may be also willing to provide free consultations for individuals who qualify. So please reach out to us and let us know kind of more details, and we're more than happy to try to set that up. But yeah, I think that is it for today's conversation. Thank you so much for your time, everyone, and looking forward to supporting your immigration journeys moving forward.